Okay, so imagine a market. And I don't mean your local Saturday morning farmer's market, where you buy jam and stuff. I mean a single continental market, one that stretches from the tip of Cape Town all the way up to Cairo, and from Dakar clear across to Djibouti.
We're talking about the African Continental Free Trade Area, the AfCFTA.
Yeah.
And the scale is it covers 1.3 billion people.
And a combined GDP of, what is it, around 3.4 trillion US dollars. I mean, it's the largest free trade area in the world if you're just counting the number of countries taking part.
It's a staggering scale. The potential here is it's massive. We're looking at lifting millions out of poverty, boosting regional income by, I think the number's $450 billion by 2035.
And that's the dream scenario, right? You have low tariffs, open borders, goods just flowing freely from Nigeria to Kenya to South Africa. But here's the reality check I want to start with today. When you have 54 different countries, all with their own laws, their own industries, their own national pride and economic anxieties trying to play by one set of rules, eventually someone is going to get mad.
Oh, inevitably. It's human nature, and it is definitely state nature. Country A suddenly slaps a tariff on Country B's widgets.
Yeah.
Country C claims Country D is blocking their trucks at the border for safety reasons. Well, they look suspiciously like protectionism.
Right. And when you have that much money on the line, trillions of dollars, these disagreements don't just lead to awkward silences, they lead to trade wars.
Which is why today we aren't really talking about the trade deal itself. We're not getting into tariff schedules or rules of origin. We're talking about the prenup.
The prenup.
The protocol on rules and procedures for the settlement of disputes. Look, I know it sounds incredibly dry, but this document is basically the only thing standing between a functioning market and total chaos.
I'm actually really excited for this one. We always talk about the shiny parts of these deals, but we rarely look at the plumbing. And for this deep dive, we've got the official agreement text, the protocols, and some really sharp analysis from the Kluwer arbitration blog to help us figure out, when the deal breaks, how do we fix it?
And maybe more importantly, does this system actually work for the reality of African trade? Because when you start digging into the articles, as we're about to do, you start to see that, well, while the structure looks robust, there might be some people locked out of the room.
So let's unpack that. If I'm a country, let's call it the Republic of Host, and I sign this deal, I'm agreeing to lower my tariffs, but I'm also agreeing to a whole new legal system. What's the core philosophy here? Is this just a court system for nations?
It's a bit more nuanced than that. If you look at Article 4 of the protocol, the goal isn't just to punish rule breakers. It explicitly says the mechanism is a central element in providing security and predictability to the regional trading system.
Security and predictability. So that just translates to business confidence, right? If I'm building a factory, I need to know the rules won't just change overnight.
Exactly. But to get that security, the state parties, the countries, they had to agree to what you could call a grand bargain. They had to accept that they couldn't use their own local courts to settle these fights.
Whoa, that's a huge deal. So if I have a dispute with you, I can't just drag you into my court where, I don't know, the judge might be my cousin.
Or where the laws are just biased towards your local industries. And this brings us to a core principle, this idea of neutrality of the forum. The Kluwer blog, they use a great word for it, they describe the system as being delocalized.
Delocalized.
Meaning domestic courts have zero jurisdiction here.
That seems absolutely essential for trust. I mean, if I'm a smaller economy dealing with a massive economic powerhouse, I need to know I'm not playing an away game where the referee is wearing the other team's jersey.
Precisely. You need a neutral ground.
Right.
But here's where it gets interesting. While they gave up local courts, they didn't really give up control. The analysis highlights party autonomy as a driving force here. Article 3 makes it very clear that countries are in the driver's seat.
Meaning they get to choose how they get sued.
Kind of, yeah. They can choose their own adventure, so to speak. They can go for consultations, mediation, conciliation, or arbitration. In fact, Article 27 says if both sides agree, they can skip the whole standard panel process and go straight to arbitration. They can even set their own procedures.
So it's cooperative. It's not like a principal dragging a student to the office. It's two peers deciding how to solve a problem.
Ideally, yes.
Yep.
And that leads to the third pillar, which, it might sound a bit controversial to modern ears, confidentiality.
I was going to ask about that. Article 17 is really strict about hearings and submissions being confidential. In a democracy, we usually want court cases to be public. Sunlight is the best disinfectant, isn't it? So why all the secrecy here?
Well, it isn't really about hiding corruption. It's about managing politics. I mean, think about the optics. If a trade dispute between two major African economies is being broadcast live on TV, the leaders, they have to posture. They have to look tough for the voters back home.
Ah, right. You can't exactly back down on a tariff if your electorate is watching and screaming that you're being weak.
Exactly. So confidentiality allows for what the analysis calls open and frank discussions. It lets the diplomats admit, okay, maybe we messed up here, without losing face publicly. It stops the dispute from becoming a media circus.
Okay, that actually makes a lot of sense. It's a safe space to fix the sausage, not just show everyone how it's made. So, we've got autonomy, neutrality, and confidentiality. Now, who are the actual referees? Who's wearing the stripes?
Well, it's a hierarchy.
Yeah.
At the very, very top, you've got the Assembly, the heads of state, and the Council of Ministers. But the day-to-day heavy lifting, that involves three main groups. First, there's the Dispute Settlement Body, or the DSB.
Dispute settlement body. It sounds ominous. Is this some panel of Supreme Court judges sitting in a tower somewhere?
No, and this is the most common misconception. Article 5 sets up the DSB, but it tells us the DSB is just. It's composed of representatives of the state parties.
Wait a minute. The DSB is just the countries themselves.
Yes, it's a
Yeah.
political body that administers the rule.
Isn't that like the fox guarding the henhouse? If the countries are policing themselves, how does anything ever get done?
It works on peer pressure and, very defined rules. They have the power to set up panels, adopt reports, monitor how they're implemented, and even authorize retaliation. But, and you have to catch this, Article 5 says they take decisions by consensus.
Consensus. So everyone has to agree. That sounds like a recipe for total gridlock.
It's a high bar, for sure, but it ensures the system is member-driven. Now, when the DSB actually needs to judge the facts of a specific fight like, are these widgets really illegal? They don't do it themselves. They establish a panel.
Okay, so the panel, these are the ad hoc judges for a specific case.
Correct. Articles 9 through 12 lay this all out. A panel is usually 3 members or 5 if you have more than 2 parties involved.
And who are these people? Are they government officials?
No, explicitly not. Article 10 says they serve in their individual capacities and can't take instructions from any government. They have to be independent experts in law or international trade. And, crucially, they cannot be citizens of the countries in the dispute unless everyone agrees to it.
Again, killing that home court advantage. Smart.
And if you don't like the panel's decision, there is one more layer. The Appellate Body, or AB, which is set up under Article 20.
The Supreme Court of African Trade.
In a way, yeah. It's a standing body of 7 people, appointed for 4-year terms. But here's the catch. They only hear appeals on questions of law. They don't relitigate the facts.
So they aren't checking if the widgets were actually red or blue. They're just checking if the panel interpreted the rule book correctly.
Precisely. They're checking the referees, not replaying the game.
Okay, so we know the philosophy and we know the players. Let's actually play the game. I want you to walk me through a dispute. I want to see how this works in practice.
All right, let's do it.
Let's say I represent country A, you represent country B, and I think you're unfairly blocking my exports of, let's say, processed mangoes.
Delicious. But hypothetical. Go on.
I'm furious. My farmers are furious. I want to sue you. What happens first? Do I just drag you to the DSB immediately?
Nope, you can't just sue. Stage 1 is consultations. Article 7 makes this the mandatory first step. The goal is always an amicable resolution.
So we have to have a coffee first.
A coffee with a stopwatch, basically.
Yeah.
If you send me a request for consultations, I have to reply within 10 days, and we have to actually sit down and talk within 30 days.
And what if I just ignore you? Or if we talk and I just stall and talk about the weather?
Well, if we haven't resolved it within 60 days, then and only then can you ask the DSB to set up a panel.
60 days? That's pretty quick in diplomatic terms.
It is. And since we're talking about mangoes, which are perishable goods, the timeline is even faster.
Oh, there's a rotting fruit clause.
Essentially, yes. For perishable goods, I have to talk to you within 10 days, and we only have 20 days to settle before you can call in the panel.
That makes sense. You can't wait 2 months while your whole inventory turns to mush. Okay, consultations fail. You refuse to let my mangoes in. We go to stage 2, the panel process.
Right. And this is designed for strict efficiency. Article 15 gives the panel a hard deadline. They have to issue their final report within 5 months.
5 months. I feel like some court cases take 5 years just to pick a jury.
Speed is currency in trade. Businesses can't wait years. And there's a unique step here called the interim review in Article 18.
What's that?
The panel writes a draft report, and they show it to us, the parties first. We get to review it and make comments before it becomes final.
Oh, that's interesting. So it's like a speak now or forever hold your peace moment.
It's a reality check. If the panel totally misunderstood a technical fact about mango processing, we can correct it before the decision is set in stone.
Okay, the panel issues the report. I win. You're illegally blocking my mangoes. Is it over?
Not quite. We enter stage 3, adoption and appeal. The report goes to the DSB. Under Article 19, the DSB adopts a report within 60 days unless, and this is a big unless, there is consensus not to adopt it.
Wait, hold on. Let me wrap my head around that. A consensus not to adopt. So that means every single country, including me, the winner, would have to agree to throw the report in the trash.
Exactly. It's called reverse consensus. It makes adoption almost automatic. I mean, why would you, the winner, ever vote to kill your own victory?
That is a very clever bit of engineering. It flips the default. Instead of needing everyone to say yes, you need everyone to say no to stop it.
Exactly. But of course, the losing party usually appeals.
And how long does that take?
Fast. The appeals are strictly limited to 60 to 90 days max. And once the appellate body rules, that decision is final and binding.
Okay, so now it's really over. The final bell has rung. Stage 4. Enforcement. You lost. You have to let my mangoes in. But let's say you just don't. You're stubborn. What happens then?
This is the big so what question, right? International law doesn't have a police force. We can't send in blue helmets to open your border. But Article 24 is clear. You must comply. If you can't do it immediately, you might negotiate compensation.
You pay me off.
Essentially. But if we can't agree on compensation, the DSB can authorize what's called the suspension of concessions.
Yeah, suspension of concessions. That sounds very polite for something that I'm guessing is pretty nasty.
It's the diplomatic term for a trade weapon. It means if you blocked, say, $100 million of my mangoes illegally, the DSB allows me to block $100 million of your, I don't know, textiles.
Retaliation. An eye for an eye.
Exactly. And think about the mechanics of that. Suddenly your textile industry is screaming at your government. They're losing money because of a mango dispute they have nothing to do with.
So it creates domestic pressure. My retaliation turns your own industries against you until you finally follow the rules.
Exactly. It makes non-compliance very expensive.
So on paper, this looks like a pretty robust system. I mean, it's structured, it has timelines, it has teeth. But this is where we need to dive deeper. The analysis from the Kluwer arbitration blog suggests it's not all sunshine and smooth sailing.
No, it isn't. When you peel back the layers, there are some pretty significant limitations, some missing pieces that could really hold the AfCFTA back.
What's the biggest one?
The exclusion of non-state actors.
Non-state actors, you mean businesses.
Exactly. I mean, think about it. Who actually trades? It isn't usually the government of Nigeria selling goods to the government of Kenya. It's a shoe manufacturer in Lagos selling to a retailer in Nairobi. It's private enterprises, corporations, SMEs.
But looking at the protocol, can that shoe manufacturer in Lagos bring a dispute if their goods get blocked?
No. They have zero standing. Only states can bring disputes to the DSB.
That seems like a huge disconnect. The people actually doing the trading, taking the risks, and facing the barriers. They can't use the very system designed to protect that trade.
That is the fundamental conflict. If that shoe manufacturer faces an unfair barrier, what do? They have to lobby their own government. They have to convince their Ministry of Trade that this specific shipment of shoes is worth spending limited diplomatic capital and tax money on to fight a whole case against another country.
And I can imagine a government might say, look, we love your shoes, but we're trying to negotiate a huge energy deal with Kenya right now. So, sorry, we are not going to rock the boat over this.
Precisely. Political alliances can often trump specific commercial grievances. The Kluwer analysis points this out. It limits the ability of private businesses to address trade problems. It leaves them totally reliant on political will.
That feels like a major hurdle for that $450 billion income boost we talked about at the start. If the engine of the economy is the private sector, but the steering wheel is held only by politicians, you might not end up where you want to go.
It's a very valid concern. The source suggests that for the system to really truly work, we might eventually need to allow private investors to lodge complaints directly.
Is there also a capability issue here? I mean, all this litigation must be expensive.
Capacity is a massive challenge. This system relies on highly skilled lawyers, trade experts, panelists. As the source notes, many African countries face capacity constraints. International trade law is incredibly complex. It's not something a general lawyer can just pick up over a weekend.
So wealthier countries with huge legal teams could just steamroll smaller countries.
It's a risk. The playing field might be legally level, but practically it's tilted if you can't afford the best representation. And this ties right back into the SME issue. Small and medium enterprises drive African economies, but navigating this complex state-level procedure is daunting and expensive for them.
So it sounds like the system kind of favors the big players, big economies, and the big companies that can lobby them effectively.
There's also a point made about ambiguity. The DSB and the appellate body, they essentially make their own rules of procedure in some areas. The Kluwer blog argues this lacks democratic legitimacy.
Because these are unelected bodies effectively writing the laws of the game as they go along.
Which brings us all the way back to Article 4. The goal is security and predictability. If the rule makers themselves are unpredictable, or if the rules are being written on the fly, the system starts to fail at providing that security.
So we have this grand bargain. The state parties agreed to give up their right to use local courts for these kinds of disputes. In exchange, they got a neutral, state-led international system.
That is the summary, yes. They traded a piece of total sovereignty for a rules-based order. And it is a massive step forward for the continent. It shows a real commitment to resolving conflicts through law, not just leverage.
But the question remains, is it enough?
And that really is the provocative thought to leave you with. If the AfCFTA is going to transform the continent, it needs the private sector to buy in. But if the private sector is locked out of the dispute room, can we really achieve that deep integration?
It makes you wonder if we'll see an amendment down the line. A Protocol 2.0 that finally lets the businesses in.
It's possible. I mean, the protocol does mention that the DSB allows for arbitration, which is more flexible. But for now, it's a club for sovereigns only.
It's a fascinating setup. It feels like building a superhighway for cars, but only letting the paving crews drive on it.
That's a surprisingly good analogy.
I try. Well, whether you're a trade policy wonk or just someone hoping to see more Made in Africa labels on the shelves, this mechanism really matters. It's the invisible wiring that keeps the lights on in the AfCFTA.
Absolutely. Without it, the agreement is just a list of wishes. With it, it's a system of law.
We'll leave it there for today. Thanks for helping us navigate all that legal text and making the dry stuff really interesting.
Pleasure.
And thank you for listening to this deep dive. Let us know what you think. Do you trust your government to fight your trade battles, or should companies be allowed to sue countries directly? It's a hot topic. Until next time, keep learning.